Thank you very much for having me here. Accommodations is a large part of what we do at Epilepsy Toronto. I should probably add that we are the only service in the country that's actually devoted to supporting the job search needs of people living with epilepsy and related conditions. So this workshop today is going to be talking a little bit about disclosure with a focus on workplace accommodations. And so I'm aware that we have lost some time. Carol, I'm going to count on you to let me know about the time, if that's all right.
Yes,
Thank you.
certainly.
So, with what time we do have, we're going to spend some time discussing accommodations and disclosure. Most of this workshop is framed around the Ontario Human Rights Code. So, within that framework, we're going to be discussing who is responsible for providing accommodations from an employer, employee, and union perspective. We're going to talk about specific accommodations for epilepsy, and we're going to break that down into seizures, into triggers, and into memory. I'm going to show you a seizure response plan that we use. And then if there happens to be time left over, we'll spend a little bit of time on discussing disclosure and different models for that. I brought a case study. There's accommodations during COVID-19, which I thought might be relevant, as well as some resources to share. So we may as well just get started and take a deep dive. A lot of people, I'm very surprised, have never actually heard the term accommodations before. No, it is not a night at the Hilton. It is a change to a work approach to account for a need or a situation that an employee has that will impact the work. Okay, an accommodation can be a process change. It can be a tool. It can be a change to the work setting or the job description. It can be a plan. Okay, accommodations are also unique to the person, to the individual being supported. Okay, these needs must always be considered, assessed, and accommodated individually. Um, Interestingly enough, some of you may not be aware that an employer actually has the right to say no to an accommodation if it is understood to be unreasonable. Okay, this is referred to as being a bona fide occupational requirement, or B4 is for short. The accommodations are also not meant to replace the essential duties of the job. What they are in place for is to actually increase productivity. So, one of the things that I find about accommodations is that it's actually fairly broadly defined. I'm sure most of you, if not some of you, are aware that accommodations for people and workers living with disabilities is actually fairly inexpensive. It's the majority of them cost $500 or less. Okay. But interestingly enough, 95% of all workers requesting accommodations are not requesting it because they have a disability. What are they requesting it for? Most of the accommodation requests are actually based on religious needs or religious holidays that take place. They're based on family needs. They can also be based upon geography or illness, weather, and lately, the latest entry into this family is COVID-19. Where we do start talking about the duty to accommodate is under the Human Rights Code, okay? So, to quote directly, Ontario's Human Rights Code provides that in Section 5, every person has a right to equal treatment with respect to employment without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, which I believe is the most recent addition, age, record of offenses, marital status, family status, or disability. Sometimes equal treatment requires accommodation. So, accommodation is we have to remember that it's a process of modifying the workplace or terms of employment to prevent a discriminatory outcome. The goal of accommodation in employment is to allow the employee to perform the essential duties of the job with dignity, individualization, and inclusion. So it requires effort on the part of the employee, short of undue hardship, to accommodate people protected under the code. The factors of accommodation include respecting the elements of dignity, which includes privacy, confidentiality, and autonomy. It includes individualization, and that has to do with the fact that accommodation takes different forms, and no two accommodations are ever going to be the same for the same two employees. It includes inclusion as well, and that is a big one because it refers to not only inclusion within the workplace, but it's also about inclusion in the accommodation process itself. It allows the worker to have a voice. It allows that voice to be heard. Okay. Accommodation is not, well, actually, discrimination for employment is not always obvious. It can have adverse effects, and that means that rules that apply to everyone but can have an unfair impact on people due to their situations. And when I talk about that, what I'm referring to, I'm talking about characteristics where a claim for discrimination can actually be found. Okay, so an employee who needs accommodation is entitled to accommodation that is reasonable under the circumstances, okay? An employee who needs the accommodation is not necessarily entitled to the perfect form of accommodation or their preferred form of accommodation. The goal of accommodation is to provide reasonably so that the employee can perform more productively. Okay, it allows the person to continue work in such a way that honors their human rights, but must result in the ability to perform the essential duties of the position. Okay, as such, it is not to be considered a make-work project for the employee. Accommodation is actually a three-way responsibility. So, as we wade through this process and try to discern who is responsible for what, there's usually three parties to the inquiry. There's the employee, the employer, and the union. Okay? And no, an employer cannot exclude the union from the process. First person we'll look at is the employer's responsibility. So once an employer has been made aware, either by the union or the employee, of a disability requiring accommodation, they must initiate the process of finding a reasonable accommodation. This process begins by making meaningful inquiries into the nature and the extent of the employee's disability-related needs. In some circumstances, the employer will be expected to inquire about the possible existence of a disability requiring accommodation. For example, in the case of a worker exhibiting unusual workplace behavior or who is excessively absent, the employer would be expected to inquire about the possibility of a disability that might need accommodation. So, part of the employer's responsibility is the duty to inquire. And this sometimes take place, an employee may not have necessarily disclosed their disability, but through anecdotal observation, the employer may determine that the worker is having some difficulty with performing the duties of the job, or doesn't necessarily appear to be exhibiting behavior that could be considered normal. All right. Sometimes this is actually a symptom of the disability, and sometimes the person exhibiting this behavior isn't aware of the fact that they're exhibiting it in themselves. I find this fairly common with some of the clients that we work with. They actually have seizures, but they kind of take it as just being part of who they are. So the employer has to accept in good faith what the employee is saying, but that doesn't necessarily mean taking it blindly. It does mean, however, being cooperative and not making assumptions. Part of the employer's role is seeking out alternatives to the situation. What arrangements are available to be able to support the employee? The employer is usually the one who's in the best possible position to understand what is required to engage in the process. There is, on the part of the employer, there is sometimes a fine line between human rights and privacy rights. Usually there is some private medical information that does need to be disclosed when an employee is requesting an accommodation. But the employer's role has to ensure that it's only seeking the information that it absolutely requires. As I mentioned before, the Ontario Human Rights Code expects the employer to accommodate an employee up to some level of hardship. However, the employer should know what will not be reasonable or sustainable, including safety issues, which we're going to talk about in a couple of minutes. I would like to spend a couple of minutes talking about both the accommodation seeker's role and the union responsibilities as well. So, the worker seeking an accommodation has a duty to disclose the general nature of their disability and any restrictions that their disability causes to the employer. This information makes it possible for the employer to properly accommodate the worker. However, the worker must provide sufficient information concerning limitations. However, revealing an actual diagnosis is not always necessary and should be avoided whenever possible. Okay. The worker should cooperate with the employer and then the union throughout the accommodation process by communicating with them and by accepting reasonable accommodation. I keep coming back to that word. So an employee who knowingly has withheld information and been terminated because of performance or attendance doesn't have the right to any accommodation whatsoever if they have withheld information. An employer cannot accommodate you if they have no sense of what the disability is or the request has not been made. The employee, however, must provide information regarding the disability, including what restrictions and limitations they have, any changes to the condition that have occurred as well, and they have to attempt modifications if it is safe to do so. There's an ongoing process that they have to remember that this is not always. Sometimes it's going to be trial and error. Sometimes there's going to be tension involved. But as such, the employee should always remember that they are a living part of the process and need to engage as much as possible. Therefore, they need to ask and answer as many questions as they can. They are expected to accept reasonable accommodation. They are not necessarily entitled to the best accommodation or even the preferred accommodation. Now, it's not an accommodation is not a way to get a preferred shift on the job or access to a particular project that they're not entitled to. Both sides have to accept some hardships in order to be productive. All right. The other issue concerning the employee is the ability to meet standards after the reasonable accommodation has been received, okay? So if you've been accommodated with the right supports and therefore been more productive, they and you're not being able to perform, the employer has the right to step in and manage you, if that makes sense. Regarding, okay, so I'm going to come down here for a second. So the employee needs to provide info so that reasonable accommodations can take place. Okay. If the employee does not disclose, they're not entitled to accommodations, strangely enough. I have literally heard people say, Lisa needs to be on a straight day shift for medical reasons. That is not good enough. You actually have to supply evidence to support that claim, and you have to determine what medical info is appropriate. Okay, so this is going to vary from case to case. The data needed to explore accommodations should be sufficient, but generally includes the general nature of the medical condition, but not the diagnosis. Okay, what are they need to know what are the limitations caused by the disability? What is the prognosis? So how long will the situation last? How long will the limitations persist? Employers have rights to this information. The employee's doctor can make accommodation recommendations, and if sometimes both the worker and their doctor will decline to make accommodation requests. So when that happens, the employer in some cases will have the right to ask their employee to submit to an independent medical exam. Okay, if more accommodations are needed, the more information needs to be provided. All right. Union responsibilities. So the union must actively be involved in the process of accommodation. Their role is chiefly in helping to determine appropriate accommodation alternatives, but they can also represent the worker's interest in meetings with the employer. The union also has to protect the interests of other members, ensuring an accommodation doesn't create undue hardship for other members of the union. In some cases, the union may need to be flexible with the application of its own collective agreement, which may include waiving certain provisions, like a posting requirement or a seniority provision. We actually experienced that in an advocacy case fairly recently with a hydro company, and they had wanted the employee to who had active tonic-clonic seizures working on a telephone pole, fixing electrical lines. Anyway, we wound up that he was working on the ground in a supply department, and that was defined as a reasonable accommodation. And I'm sure you can see why. Okay, so we have talked a little bit about this. When an employer is considering accommodations, two of the most important factors to take into consideration are financial and safety. Financial costs must be directly related to the accommodation. Now, the good news, again, most accommodations are really, really affordable, costing less than $500. They must be proven and not merely speculative, and they must be substantial to the point that the viability of the operation is impaired by the cost. Safety concerns must also be taken seriously. Employers sometimes try to claim that safety concerns as an excuse to avoid their duty to accommodate. In determining the point of undue hardship, safety concerns must be real and reasonable, not based on speculation. It can include the safety of the employee seeking accommodation, coworkers, and other stakeholders. Okay, we've talked about the employee's role in accommodation. We've talked about providing medical. So I'd like to turn some of our time to the union's role. And we've talked a little bit about this. already. What we can say is, in some cases, the union may need to be flexible with the application of its own collective agreement and also help both parties navigate through that collective agreement as well. So I think there was a mistake with the slide. When we talk about undue hardship, okay, there is no right to accommodate an employee beyond the point of undue hardship on the part of the employer. It's got to be done on an objective and a quantifiable basis. It can only be, it's often related to monetary cost or health and safety. One thing I would like to point out that we don't talk about very much is frustration of an employment contract. This can occur when a contract is impossible to perform and it is not the fault of either party due to a contract and was not anticipated when the contract was first conceived. The employment can be frustrated due to injury or illness. The employee is usually still entitled to notice of termination and severance pay under the Employment and Standards Act of 2000. The employment will not be frustrated if it would disentitle an employee from group insurance benefits. All right. How are we doing for time? Carol?
Sorry, I didn't have a microphone and I was speaking.
Sorry about that.
No, that's okay. So I would say about 5 more minutes, just because we want to give the participants some time to ask questions.
Absolutely.
Yeah.
Okay. Okay. All right. So I want to just shift perspective a little bit and spend the next couple of minutes discussing epilepsy specifically. You cannot generally, the number one reason for disclosing a disability in the first place is usually to request accommodations. Okay. So when decisions are being made about sharing information, it should really only be job relevant and focus on the medical condition. Okay. Relevant factors that need to be considered during the disclosure process include how the disability impacts on the job, social factors, what kind of accommodations required. Telling them that you have, telling the employer rather that you've got a disability for the sake of letting them know is simply called awareness. That's not disclosure, okay? So when we work with our clients at Epilepsy Toronto, one of the very first things that we do when we're taking an intake is we try to create a seizure profile, and we try to marry this in terms of a reasonable goal setting for a person's employment objective. Here, we're just going to look at accommodation requirements, and I'll introduce you to a form that we use quite frequently. So some of the variables that we take into account are things like the seizure type. Does the person fall or convulse when a seizure occurs? Does the person have any warning before they have the seizure? It used to be known as an aura. Do the seizures occur in clusters? Are there known triggers? Are the seizures predictable? Do they have any kind of discernible pattern? And what is the post-ictal behavior that we are asking about? In terms of the workplace, what kind of issues are we looking at around the epilepsy? So it could be triggers in the environment or with the job. There may be flashing lights, for example. There may be visual alarm triggers. There may be particular hazards relating to machinery, chemicals, hot surfaces, heights, other things, and possibly coworkers as well. So this brings us to several mitigation strategies, and we've created this chart that sort of shows different tactics that can take place depending on the requirements for accommodating seizures. You will be receiving copies of the slide deck and be able to explore this a little bit more. But it's done with the understanding that safety is the top priority, okay? Sometimes you're able to reduce the impact of a seizure by changing elements of the environment, working flexible shifts, having a buddy system, and having a seizure response plan, which I'd like to talk about in a second. And we're going to head right there. I'm going to skip over this part. We've talked a little bit about flashing lights for triggers for epilepsy. I'd like to spend 2 seconds talking about accommodations for seizures. So the process for knowing what to do in the event of a seizure, we have a seizure response plan in place. We try to provide training for staff. And then we try to do an environmental scan, and we're looking for things like rounded desk edges. We're looking at floor mats, fall detectors, how clean or messy the space is, and if it might result in injury. Things like keeping a pillow or a change of clothing accessible in a closet. These are all very cheap and practical things that you can do to support a person living with epilepsy. Of course, it's going to depend on the type of seizure that they have, and there are over 40 of those. Others can include alternate transportation, a buddy system, or working from home. A lot of people with epilepsy also have problems with memory. So we have a long list of memory aids and supports in place for them. And it could include things like a note taker, making to-do lists, instructions that are both verbal and written so the person has something to refer to, getting the person to recap to demonstrate that they're actually understanding, maybe receiving an outline of the minutes in advance so that they can be able to contribute. It also helps to know what type of memory issues the person is living with. Is it short-term memory? Is it working memory? Is it auditory? Is it visual? So, and I'm going to stop it there. We have a copy of the seizure response plan, which I think will be very useful, and I can show this to you later. But right now, I think it might be a good opportunity to open the floor for any questions.
Yes, and thank you very much, Carter. So could you is there a link that you can put in the chat box for what do you call it?
So should I escape first?
The response plan. No, you were saying before that there was some information that you could have provided. Is it in the form of a link that you can put in the chat box for the participants to access?
Oh, I see where you're coming from.
Oops,
There
sorry.
are resources. Is it okay if I show you to answer that question with a visual very quickly?
Yes.
Okay. So this is an example of the seizure response plan. And you can see that the types of seizures are being recorded, when it happens.
Could you go in? Sorry, could you go into from beginning so that we can see it clearly, because it's showing very small and at my.
Oh, sorry. All right. Let me just go back here. There we are. Okay. So this is what Epilepsy Toronto uses.
Sorry, we're not seeing it.
Oh, no, you're kidding.
Yes, that's it now. Yeah.
You can see it, though, yes?
I'm seeing it now, yes.
Okay, good. All right. So you can see that it collects very, very detailed information about the person, their phone number, alternate contacts, what the triggers are, what medications the person is collecting, different seizure types if there's more than one. There are also special instructions regarding first aid for people who are unfamiliar with seizures, and of course it walks you through moving dangerous objects away, staying calm, not putting anything into the mouth. and it also guides you when to call 911. So there's a list of emergency contacts. Sometimes people have rescue medication if they're having cluster seizures, and there will be guidance on how to administer that. So
Okay.
that's a fairly substantial document,
Okay.
and that is going to be in the slide deck, and it's
Okay.
also accessible on a resource called epilepsyatwork.com, which is completely free for access, and it's in
Okay.
the resources section.
Okay, so that would be in the slide. Okay.
Yeah,
So what I'll do now, participants, if there's anyone that have, you have questions, you can type it into the chat box, and I will read it out. Thank you so much, Carter, for this information. I know we had some technical difficulty in between, but sometimes that's unavoidable, right? Um,
unfortunately.
yes. So while I'm waiting for participants, if you have questions to type in the chat box, I have a question.
Sure.
So I have been hearing from patients from time to time, they're working, and once the employer finds out that they're living with epilepsy, they are fired for whatever reason, right?
Hmm. Hmm.
And there's nothing done, uh, about it. And so I wanted to know from you, is that something that the employer can do?
No.
You know, okay. So what
Hand
could the patients do? Like, what would they have to do to advocate for themselves? What steps do they take?
hands down, that is a hard no. So what steps do employees take? First of all, I think it depends. Part of this presentation dealt about when the best time to disclose what was, and there really is no best time. If I can answer that generally, I would suggest that one of the better times to disclose a disability would be after you've been hired, and perhaps after the probation period has concluded.
Mhm.
And I'm assuming that the person who you're referring to, in that circumstance, potentially got they disclosed very, very early on in the hiring process. But if you have had, let's say, a 3-month probation, and you've had an opportunity to demonstrate the skills that you're bringing into the job, and of course, you're not going to be applying for a job that you're not qualified for. It also gives you an opportunity to observe the culture of the employment and learn a little bit about what some of their HR policies are, find out if there are inclusion and diversity supports for people with disabilities, and enables you to establish a bit of a relationship with the employers. So I know that's kind of a roundabout way of answering your question, but I would say, if you are going to disclose, always have it in writing, and make sure that you understand what your rights are. The employer by no means can fire you for simply having epilepsy. It is embedded in the Human Rights Code that is illegal. And now you have the AODA legislation that is reinforcing that as well.
Could you say what the acronym is just for persons who might not know
Yes,
what we're about?
yes, it's the Accessibility for Ontarians with Disabilities Act.
Okay. And so, because I've come across quite a few patients that have said, once the employer finds out they have epilepsy, they would let them go. And I would think, so if that happens, is it like, okay, I guess you can't refuse if the employer fires you. Like, what can you do to fight back or to secure your job, or even if you're fired, like, what can you do to take action? I mean, I know that
Mhm.
you said earlier, you can disclose in writing, um, and so that the employer knows, right? But is there a part where, well, when you're disclosing, do you at that point say, these are the accommodations I would like, and then you negotiate, or how does it work exactly?
Well, that's a really good question. And again, it's going to vary from situation to situation. Every person's disability is going to be different, and therefore their accommodations may be different. Um, One thing that I like to advocate is have a doctor's note with you at the time that you were hired.
Mm-hmm.
Um, not to choosing not to disclose does not necessarily mean that you are being deceptive. It does mean that you want to be given a chance to be able to demonstrate what skills you bring to the job
Yeah.
and the role. So, and again, I want to emphasize that it is illegal for someone to fire you because of the fact that you happen to have a disability. So, we sometimes get phone calls from employees who are living in smaller Ontario towns who have been let go, and the employer actually had no concept of the fact that they were committing an illegal act. So, um, there are various ways that you can approach this. I'm always a big fan of education. That's probably my number one response. And the other thing is calling your local epilepsy association, of which there are many across the province that can provide that education for you. There are also online resources. Epilepsyatwork.com is a really strongly recommended resource as well. Um, the other thing too is that I would recommend that if you are going to be put in a position, understand what your rights are, understand how to articulate what your needs are, and be able to express those clearly and concisely to the employer.
Okay. And so that do they have any what do you say? Do they have any responsibility, for want of a better word, to rehire you if you decided that you wanna to uh resist the their letting you go? Do you have, is there anything that the employer can do to secure their position, like the employee to secure their position, or
Well, I think
can they fight back then?
sure they can. Yeah, they can
Oh,
absolutely fight
somebody has
back.
a
But
question.
the
Go
question
ahead.
is, okay.
No, you go
Oh,
ahead,
oh,
and I'll
oh,
repeat
I'm sorry, I'm
after.
sorry, I'm sorry. I guess, one of the questions we have to ask ourselves is if something like that has happened in the first place, do you actually want to go back and work in that kind of an environment that discriminates against people with disabilities? Chances are they're going to discriminate against other communities as well. But having said that, it goes back to what can the employee do is your question. And yeah, I mean, the employer can rehire you and renegotiate your contract. And if you are going to be doing that, I would suggest that you get an agreement or an understanding in writing, possibly that's been um, um, authorized by a lawyer or notarized by a lawyer, that this becomes perhaps a legal understanding of what your disability is, what it constitutes, how it may impact work, and the accommodations that are required for it. So that would
Okay.
probably be a good first step.
Okay, thank you for that answer. I have a question. So one of our participants is saying, my understanding is that there is probably a big percentage of people living with epilepsy that are unemployed due to lack of driver's license, job requirements, finding hours that work with their needs. People that I have talked to do not feel comfortable disclosing their epilepsy, so either go from job to job trying to find one that works or struggles with unemployment for various reasons. What can be done to help people that are living with epilepsy find work? In particular, sorry, I'm trying to, in particular, people living in rural areas without access to services that can help them.
Well, first of all, I think there are always going to be access to services via the computer these days. So hopefully that can help. Usually there is, I can't remember the number of epilepsy chapters across the province, but there is usually one that's responsible for a territory near you. And yeah, you're absolutely right. I mean, and compounding that difficulty of disclosure is the fact that epilepsy is a disability that is both invisible and episodic in nature. And sometimes, even when the person is actually having the seizure, it's not noticeable. So, you have to ask yourself, what mechanisms do you have in place to be able to make it safe for the employer? There was a study done about 10 years ago, and uh, in terms of disabilities and comfort levels, and invisible disabilities and mental health place dead last in terms of people feeling comfortable to actually disclose. So that talks to you a lot about stigma that people feel. Sometimes people have internalized those negative messages because it's been a consistently negative impact, and that's been reinforced over a period of time. First of all, I want to point out that the majority of people living with epilepsy, especially if their epilepsy is fairly well managed, can do most any job. Okay, now that's within reason. I mean, I'm going to ask you to think twice about you will not be able to be a pilot. In a lot of the cases, you will not be able to operate firearms. In a lot of the cases, you will not be able to be a lifeguard, for example, if your seizures aren't controlled. However, you need to understand what your disability is. You need to be able to understand how it impacts you. You need to be able to make it safe for the employer. And it's not enough just to disclose. You need to bring solutions to the table as well, such as this personal seizure plan. I get it. Disclosure is difficult. It's private. It's probably the number one concern that is brought to us after people have been hired. And the employer can also turn around and cultivate disclosure positive environments. They can put up posters for welcoming people with disabilities. There are programs where they can start employees with disabilities and networks for them, and professional development for staff. There's a lot of different things that can be done, and a lot of different really good things that have been done, which help facilitate the disclosure of a disability for people. You're right, it's going to be more difficult in rural areas. One thing I'd like to point out, so I just really finished very, very quickly. So the Ontario Chamber of Commerce has 67,000 members across the province of Ontario, and they have a wide range of disability services at their disposal as well. And they work very closely with employers about cultivating disclosure positive environments. And so I would also look there as well.
Okay.
Yeah.
One last question quickly. We're out of time, but I just wanted to ask. So, understand correctly that you support folks with epilepsy in job hunting. Is this primarily within Toronto, or do you support or partner with other organizations in the York region? Just a quick question.
The answer is yes. We do partner. There is an epilepsy chapter in Richmond Hill. And as a matter of fact, we were just in touch with them a couple of days ago, and we're going to be collaborating on some workshops. So yes, absolutely. We can provide support in that regard.
Okay, thank you so much for that. So we have come to the end of our workshop.